That's why Miss Gillette is doing this. My attorney already told me Miss Gillette does not like me. That comes from Miss Gillette to my attorney. That's a conflict of interest. And on the record and for the record, and let the record show.
Mr. Perez-Beal.
On the record, on and for the record, and let the record show, I have the right to take my accuser, and the accuser must be a living man or woman. Therefore, I move to dismiss the case entirely. Must my accuser be a living man or woman?
This case is everything you expect when a self-proclaimed sovereign citizen steps into a real courtroom. Bold claims, legal buzzwords used completely out of context, and a judge who has clearly seen this movie before. From the very first sentence, the defendant frames himself as a victim of a grand conspiracy, accusing prosecutors, judges, and even livestock thieves in one breath. He isn't just denying trespassing, he's trying to place the entire legal system on trial. The problem? Courtrooms don't operate on internet mythology or YouTube tutorials. They operate on law, procedure, and evidence. What makes this hearing so fascinating is the clash between reality and belief. On one side, you have a calm judge patiently explaining constitutional rights, penalties, and options for legal counsel. On the other, a defendant who refuses to engage with any of it unless it fits into his personal narrative about living men and women in magical dismissal phrases. Throughout this video, watch how the judge balances patience with authority, slowly narrowing the conversation back to the actual
Are you Antonio Manuel Perez-Beal?
Yes, sir, I am. Yes, Your Honor, I am. No, I do not. But I do believe I have the right to face my accuser. And on the record and for the record, and let the record show.
Mr. Perez-Beal, this is your first appearance. You are charged in count 1 with criminal trespass, a Class B non-person misdemeanor. A Class B non-person misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. You understand what you're charged with?
On the record, on and for the record, and let the record show, I have the right to take my accuser, and the accuser must be a living man or woman. Therefore, I move to dismiss the case entirely.
Well, that's not going to be done. Mr. Perez-Beal, I asked you a question. Do you understand what you're charged with?
No, I do not.
All right. What is it that you don't understand about the criminal trespass charge?
I don't know why I'm being charged with a criminal trespass. I have the picture of me and my children over there on November 23rd or 27th. I'd have to go back and date it. My livestock, please let me finish, Your Honor. My livestock come up missing. Whenever that man, I had that leased. Whenever that man come down here, my hot wire come up missing. The fence that divided our two properties. He cut a hole in his fence. I have a witness who is a neighbor stating that he's seen a young man and a young woman out there removing that hot wire. I've never once had a problem. He showed up, our hot wire come up missing, and a hole got in the fence. Whenever that happened, I called one of your deputies, Deputy Joe Love. He showed up to the scene.
All right, Mr. Perez-Beal.
I have a right to look for my missing livestock.
Mr. Perez-Beal,
I'm filing an interlocutory appeal.
You need to stop talking for a moment. This is a first appearance.
Well, this is wrong.
Sir?
Here's where the pattern really starts. He says he doesn't understand the charge, but instead of listening to the explanation, he immediately launches into personal stories, accusations, and unrelated events. This is very common in sovereign citizen courtroom encounters. Confuse, deflect, redirect. Rather than addressing the specific allegation, criminal trespass, he turns the hearing into a narrative about missing livestock, fence wires, and neighbors. But notice something important here. Confusion and disagreement are not the same thing. He isn't actually confused about the charge. He simply doesn't accept it. Courts, however, don't ask whether you spiritually agree with a statute. They ask whether you legally committed the act described. This is also why a lawyer would be extremely valuable to him right now. An attorney could separate emotional frustration from relevant legal arguments. Instead, he tries to argue everything at once, and the more he talks, the deeper he sinks. What do you think? Is he confused, or does he just not like the answer he's being?
This is a first appearance. At that time, what I do is I go over the charges, what the potential penalties are, and try to explain to you your rights. Please do not interrupt any further. Do not go off on tangents. I'll have some questions for you that you'll need to address. First of all, in regards to your rights, you have the right to a trial, either to the court or if you request in writing a request for a jury trial. At a trial, the state has the burden of proof. The burden of proof in a criminal case is beyond a reasonable doubt. At a trial, you have the right to be represented by an attorney or to represent yourself. You understand you have the right to, at a trial, to cross-examine the state's witnesses and to call witnesses on your own behalf. You may use the court subpoena power to be sure that other witnesses appear. Do you understand these rights?
Yes, sir.
All right. Now, at a trial, beyond the right to cross-examining the state's witnesses and calling witnesses on your own behalf, you have the right to either testify or not testify as you see fit. If you choose not to testify, then that cannot be considered against you into determining if you're guilty or not guilty.
Must my accuser be a living man or woman?
Okay, Mr. Perez-Beal, I'm not sure where you're getting this.
The Sixth Amendment.
All right, this is the first appearance, as I've indicated before. Now, if you wish to be represented by an attorney, you can hire one or you can apply to the court if you choose.
Let's take this to trial. I want a jury trial.
All right, first of all, let's answer the question about the attorney. Are you going to represent yourself or are you going to hire an attorney?
I will, at this point, I'll represent myself. And if I have the fine.
You blocked out, Mr. Perez-Beal.
Can you hear me now?
Now I can hear you. The last thing I heard before it blacked out was in regards to you're going to be representing yourself, and that you.
I will represent myself unless I'm financially able to hire an attorney. But last time I spoke to my attorney, Mrs. Mary Ann Shirley, she told me that Judge Jill Gillette does not like me. That's where all this is coming from.
First of all, Ms. Gillette is not the judge. I am.
You've
been before me before.
Yes, sir, I know.
All right. So are you still on probation?
Yes, sir. As far as I know.
Well, if you're on probation and convicted of a new offense, that'll be a violation of that probation.
That's why Miss Gillette is doing this. My attorney already told me Miss Gillette does not like me. That comes from Miss Gillette to my attorney. That's a conflict of interest.
This is one of those moments where the judge's patience becomes the real star of the show. The defendant is insisting on explaining every grievance he's had for months, while the judge is simply trying to complete the first appearance checklist. Read charges, explain rights, determine counsel. That's it. No trial, no witness confrontation, no cross-examination, just the basics. Yet the defendant keeps pushing as if this is already a full-blown jury trial. The judge's interruption is critical, not rude. Courtrooms must stay on track, especially when defendants try to overwhelm the process with unrelated commentary. If judges allowed this to go unchecked, hearings would last days and achieve nothing. The key takeaway? Procedure matters. There's a time to talk about evidence, a time to tell your side of the story, and a time to be quiet and listen. Right now, The defendant is choosing the exact wrong time for each of those things, and it shows.
Right now, you don't have an attorney on this case. Is Ms. Marianne Shirley going to be, are you going to hire her on this case?
I will talk to her, but Gillette knows what she's doing. She likes tearing families apart. What happened when Karma finally
Mr. Perez
come to yours, Gillette?
Mr. Perez-Beal, you've indicated that you want a trial. And you also indicated that you wanted to have a trial by jury. To do that, you have to file a written request for a misdemeanor.
I have to file a written request.
If you are going to be representing yourself, you need to understand there's disadvantages in that. One disadvantage is I don't believe you have the training that an attorney has.
No, but I also don't have everything I make's going to try and keep our home and stay afloat right now.
Right. As I indicated before, if you wish to have an attorney but cannot afford an attorney, you can apply to the court. If you meet the financial guidelines, then I would appoint an attorney to represent you. If that may not be an attorney that you select.
I will talk to Miss Marianne Shirley.
All right. So if you're going to talk with an attorney, typically what we do is we schedule another hearing to give you that opportunity. And we call that a control hearing or a status hearing. Do you wish to do that, or do you wish to go ahead and schedule a trial?
If we schedule a trial and I show up with an attorney, will that be allowed?
Well, it would, but if you're asking for a jury trial, there's certain things that you have to do. Right now, you're representing yourself. That can be, you need to understand that the disadvantage that people have by doing that sometimes is more than others, but you will be required to follow the rules as you are an attorney if you're representing yourself. Most people don't know what those rules are and so forth. So that presents a real disadvantage at times. Do you understand that?
Yes, sir.
Okay. So if you're going to apply for an attorney or talk with Ms. Shirley, what I'll do is schedule a control hearing. That is not waiving your right to a trial, all right? If that control hearing or status conference, which we'll set in about 30 days, if you still wish to have a trial, we'll schedule that. We can schedule for either in person, either before the court, or you can be represented. If you wish to have a jury trial, you need to have your request made in writing for that, and we would schedule a trial by jury. Now, there was a hearing that was scheduled on December 13th, and you did not.
This is where we see one of the most common sovereign citizen misunderstandings, invoking the Sixth Amendment without understanding what it actually guarantees. Yes, the Constitution grants the right to confront witnesses, but that doesn't mean the accuser must be a living man or woman standing in front of you at arraignment like some medieval duel challenge. In criminal law, the accuser is the state, represented by prosecutors and supported by evidence, reports, and testimony presented at trial, not at the first appearance. He's quoting constitutional language, but stripping it of legal context, which is incredibly dangerous for defendants who represent themselves. Knowing words isn't the same thing as knowing law. A trained attorney could explain that confrontation of witnesses happens later, at trial, not during a procedural hearing. Instead, he believes he's discovered a magic phrase capable of dismissing the entire case on the spot. Unfortunately for him, courtrooms don't run on magic words. They run on procedure, timing, and legal definition.
Appear at that time. I issued a bench warrant, and you had been served with a summons. Now, later that day, you contacted the clerk's office, and then you did surrender yourself and posted a $5,000 cash or surety bond, and that bond is still in effect. All right.
Yes, Your Honor.
So
Yes, Your Honor.
Now the stakes become crystal clear. The judge reminds him that he is currently on probation, which means any new conviction isn't just another charge. It could trigger probation violation consequences on top of the new penalties. This is the moment where most people would immediately want legal counsel. Yet instead of recognizing the seriousness, he doubles down on conspiracy claims about people not liking him. Probation status changes the entire risk landscape. A small misdemeanor can snowball into jail time not because of the new case alone, but because it violates existing court orders. The judge is basically waving a bright red warning flag, and the defendant is driving right past it. This is why judges constantly advise defendants against self-representation. The law contains landmines you don't even know exist until you're standing.
You need to be sure that you appear as directed for later hearings. Now, let's go ahead and schedule this for a control hearing to give you an opportunity, Mr. Perez-Beal, to speak with an attorney of your choice or to apply for an attorney. Please do not wait until the last minute to do that here, if you want to apply. If you're going to apply, do so in the next few days. If you're able to hire an attorney of your choice, that's fine. Then the court-appointed attorney would be released from dealing with the case. All right. Now, January 31st at 3 p.m.
January 31st at 3 p.m.
Okay, Mr. Perez-Beal, you're breaking up a little bit
And
on your connection.
can you hear me fine now?
Well, it comes and goes. Right now, yes, I can hear you.
Can you hear
Now we can't hear you.
fine now?
There's also a time delay. You know, I'll see your lips move, and then we'll hear the sound. We call it lag, or I call it lag. Mr. Perez-Beal, now you're frozen, and we haven't been able to hear you for the last 30 seconds or so.
I'd just like to make a statement.
Well, you've made some statements, but
Can you hear
right
me now?
now we're scheduling January 31st.
How about now? Are you able to hear me?
Now I was able to hear you. You interrupt me, but our next court hearing is January the 31st at 3 p.m. That will be a Zoom hearing. You understand? Do you have that? Mr. Perez-Beal, did you hear the date?
Yes, sir.
Okay. Can you repeat the date so I know that you've got it, please?
January 31st at 3 p.m.
Correct. Because
By Zoom.
that'll be a Zoom hearing, but I want you to appear at the sheriff's office so that we don't have this problem here. If you have an attorney and the attorney would prefer to have you there at their office to do the hearing, then that's fine too. So if Ms. Shirley is going to be your attorney, you hire her, and she wants you to be but you need to be at one of those two places, either the attorney's office or at the sheriff's office where they have the equipment, and we can be relatively sure that you're going to have a good connection. In this hearing, we haven't had a good connection.
Yes, sir.
All right. That's the things that we needed to cover for today. So this matter will be adjourned, and we'll see you on January 31st at 3. So Mr. Perez-Beal's case is adjourned at this time. All right. I need you to mute him.